The person that I will be eventually getting married to is who she looks at as dad.
The state typically would ask for DNA testing, but typically we also don't have the presumed father participate in any fashion. So if this court finds that the evidence presented by Mr. Burkey and Ms. Ryan is sufficient to go forward and exclude him from the case, the state will just ask that we reset and order DNA testing for Mr. Williams.
All right, Ms. Gone.
Judge, I would join the court in that. As the court is well aware, it is a presumption that can be defeated with testimony. And I don't think I need to remind the court that witnesses are presumed to be competent. For the record, the gentleman who is here is the respondent in another matter in his divorce action with my client, Ms. Ryan. For the record, their cause number is 24 DFAM 346678 out of the 264th. And in that, that divorce has not been finalized. There was one child born of, and that is the child we're addressing here. So we're respectfully asking the court to defeat the presumption for the husband. Again, you have 2 matters pending. So that's why we've asked this individual to be here.
All right, thank you.
At this time, I would call my client, Ms. Ryan.
Yes.
Ma'am, would you state your name, please?
Alexandria Ryan?
And you are the same Alexandria Ryan that was called to court today in this establishment case. Is that correct?
Correct.
Okay. And you are the mother of, is it Riley Lynn Williams?
Correct. Yes.
Okay. At the time the child was born, were you married to Mr. Burkey?
Yes.
And he is the same individual that is present today in court. Is that correct?
Correct.
Okay. Now, it's also my understanding that you have filed a divorce with Mr. Burkey. Is that correct?
Correct.
Okay. And although you are presently married to Mr. Burkey, are you telling the court, both in this action and also in your divorce action, that there was one child born, and that is the same child, Riley, correct?
Correct.
But you are also going to testify, not only in this court, but also in your divorce proceeding, that Mr. Burkey is not the father of Miss Riley Williams. Is that correct?
Yes, correct.
I show on the styling of both cases that there is a last name Williams. Who do you believe the father of that child, Riley, is?
Justin Williams.
Okay. This is the same Justin Williams that was called to court today. Is that correct?
Correct.
If the court finds it appropriate, and obviously you and I have gone over this a little bit before court today about what the presumptions are when a child is born of a marriage, correct?
Correct.
Okay, and you understand that Texas doesn't have legal separation. You are still married to Mr. Burkey, and the court has to entertain testimony today regarding the presumption that the husband, that is Joshua Burkey, is the father of this child. Is that correct?
Correct.
Okay. Are you asking the court to find freely and voluntarily, without any coercion against you, are you asking the court to find that Joshua is not the father of this child?
Correct.
You understand that if you testify to that and the court agrees with you and finds cause for that, that you cannot go back and then say, well, I've changed my mind, or, actually, that relationship didn't work out, so now I want to go back and go after some other individual. You understand that?
No, I understand. We have been separated for 7 years.
Okay, and you sort of touched on what my next questions would be. When the child was born, was Joshua present?
No.
At the birth? Okay. Was Mr. Williams present?
Yes.
Okay. I hate to ask a woman who just delivered a child this, but I'm going to ask you to go back in time for just a moment. When you were I presume it was in the hospital, were you given paperwork regarding Riley as far as a birth certificate or any other paperwork?
Yes, I was.
Do you recall what that paperwork was, ma'am?
I know the Social Security paperwork, the birth certificate paperwork. Justin tried to sign the birth certificate, and the nurse told him no, because I was still technically married and he was not allowed to sign.
Okay. Do you recall, did they give you, somebody at the hospital, did they give you any other paperwork regarding establishing paternity on Riley?
No.
Okay. Is it your testimony, again, is it your testimony that Joshua is not and cannot possibly be the father of this child?
Joshua is not and cannot possibly be the child of Riley, or the father of Riley.
Okay, past and state.
Ms. Bond, got your witness.
Your Honor. And ma'am, how old is Riley?
She is a little under a year and a half.
And ma'am, you said you and Mr. Burkey were separated for 7 years.
We have been separated for 7, yes.
When specifically was the last time you saw each other prior to Riley's birth?
7 years ago.
We're not the witness yet, Mr. Burkey, just a moment, thank you. That's okay.
Ms. Ryan, can you please repeat that?
About 7 years ago.
And to this
Or-
day, ma'am,
yeah.
does Riley consider Mr. Burkey or any other person her father?
The person that I will be eventually getting married to is who she looks at as dad.
And that person is not Mr. Williams, whom the state is asking to be adjudicated as father?
No, he doesn't come around, nor does he talk to her.
Thank you, ma'am. Your Honor, I pass this witness.
Anything on redirect, Mr. Gaunt?
No, ma'am, I don't believe, well, I'm sorry, no, Your Honor, let me,
Go ahead, go ahead.
Just-
That last part just kind of got the hair stood up on the back of my neck. Right now, based on that, I'm probably looking at the order and seeing Mr. Burkey let Mr. Burkey take a DNA test. This sounds like it's getting ready to get complicated. So, but I'll go ahead and let you try to let you readdress Ms. Ryan. Thank you.
Ms. Ryan, again,
Yes.
are you asking the court to find, after your testimony, are you asking the court to find that for the presumption that Mr. Burkey is not the father of this child?
Mr. Burkey is not the father of this child.
Okay, Judge, that's all I
Justin
have.
Williams is the father. He
Judge,
was
that's
a part
all.
of her life up until a couple months ago.
Okay, Judge, I think we're kind of losing our, hopefully preserve record. I have no other questions of this witness.
Any other questions of Ms. Ryan, Ms. Mungat?
No, Your Honor.
All right, Mr. Gaunt, call your next witness, please.
Call Joshua Burkey.
Mr. Burkey, you're muted again, so please unmute. Thank you.
I'm here.
Thank you. You may proceed, Mr. Gaunt. Thank you.
Mr. Burkey, you've heard the testimony from what is at present your spouse. I know you all are in the middle of getting a divorce. If I had asked you the same question, would your answers be the same?
Yes.
You are Joshua Thomas Burkey, correct?
Yes, sir.
And you are telling the court freely and voluntarily that you are not the father of Riley Lynn Williams?
Correct.
Okay. And as I understand it, then you and my client have been separated for quite some time. Is that correct?
Yes, sir.
Again, sir, when was the last time you all saw each other? When's the last time you all lived as husband and wife? Let's start there.
I'd say 2018 is mid-July 2018 last time I seen her.
Okay. And then since that time in 2018 until today, when's the last time you saw my client?
Haven't.
I'm sorry, say again?
I haven't seen her.
Okay. Do you recall at any point in time, have you been presented with any paperwork, any legal documents from the state or from anybody else, including my client, asking that you be adjudicated or asking to make a finding on paternity on this child?
No, I've just received the divorce papers or whatnot.
Okay, it was a poorly worded question. What I mean is, have you received anything, for example, from the Attorney General's office asking you about paternity on Riley?
No.
Have you received anything from a health insurance company or from the hospital where she might have been born or whatnot? You haven't received any of that paperwork?
No, sir.
Okay. And again, are you also asking, basically on grounds of impossibility, are you asking the court to find that this child, you are not the presumed father and in fact are not the father of this child?
No, I'm 100% not the father of this child.
Pass the witness to stay.
All right, Ms. your witness.
Thank you, Your Honor. Mr. Burkey, you appearing today was completely voluntary, correct?
Yes.
And so until you were requested to appear, you didn't know that the state of Texas had named you in our pleadings as a presumed father, someone we think, well, someone who could be dad, but in this case is not, correct?
Correct.
And so, sir, was there anything else you wanted the court to consider at this time? Thank you,
But I
sir.
know it.
Your Honor, I pass this witness.
All right, Mr. Gaunt, anything on redirect, sir? You muted, sir.
Nothing further unless I can address the court directly, just for a moment. Nothing.
I was going to go ahead and you have no other witnesses at this time, correct?
That is correct, Judge. I would like to address the court for a moment, but yes, that is correct. No other witnesses.
All right, then. Ms. Mungat, any other witnesses from the state?
None, Your Honor.
All right, then I'll let this address be the address and closing statements. So however you want to call it, Mr. Gaunt, I'll start with you and then go to the state. Thank you.
Judge, I would ask the court to take judicial notice of the file, including what I note on the state's filing dated April 19th, where it indicates that the state denies that Joshua Burkey is the biological father of these children. Obviously, my client is present. Mr. Williams was served and filed notice and has not appeared. Again, based on what amounts to impossibility, as the court I'm sure is well aware, the presumption is only that, just a presumption. For the record, I do not represent Mr. Burkey. I represent Ms. Ryan. But again, given the length of time between these two and their desire to extinguish their legal relationship through that divorce, and the fact that there were no other children of that marriage, for what that may be worth. Again, I think the testimony is clear. Mr. Burkey is here of his own accord, and my client has freely named this other individual. The state has tried to serve this individual. He's filed notice. For our purposes today, again, I would ask that the court make a finding that the presumption of paternity toward Mr. Burkey has been defeated by the testimony here. I certainly understand the state has a vested interest in establishing paternity. And again, I believe the testimony is that Mr. Williams is the only one that could be the father of this child. Whatever else may be going on in my client's life, the biological physics of this are that Mr. Burkey is not the father. We would ask the court to find accordingly.
Thank you.
Okay.
Your Honor, nothing different from my opening statement. I ask the court to consider what's been presented and rule appropriately.
All right, Ms. Gunn, normally I would go ahead and do that, but this one looks like it's getting ready to get messy. I'm not sure if this guy's going to cooperate going forward. We may have to do the default where he doesn't show up for his DNA test 3 times, all that. That's just scared the daylights out of me, and that's going to take months for us to get through that part of this matter. So, and I can get Mr. Burkey seems like he's cooperative. He can get a DNA test sometime this month and be eliminated, and he and Ms. Ryan can get their divorce, and you'll have the necessary documentation at that point that he's not the dad. You can present that to the district court, and I can go and the state can present it here, and we can eliminate him 100% without running into anything that's going to be problematic. Because right now it sounds like this is really getting ready to get problematic. Because I'm understanding from Ms. Ryan and that she and the alleged father are not not in the best of places right now. So at this time, Mr. Burkey, you have a problem taking a DNA test. It's a mouth swab, sir. It won't take you that long. You have a problem doing that, sir?
No, sir, not at all.
All right, good enough. Let's go ahead and do that, because again, I can just see that part, your part of the case, Ms. Ryan and Mr. Burkey, it sounds okay, but the other part is, yeah, it sounds problematic. So anyway,
Judge, if I may.
Yes,
yes,
ma'am.
sir.
Judge, I don't mean to add more to this, but it's my understanding Mr. Burkey is out of state and I believe resides in Oklahoma. So if we're going to do a DNA test, I would ask that he be ordered. And I think we could do it pretty quickly because my client's local. She could go into 704. I would ask that Mr. Burkey be ordered. I'm putting a soft quote on that. He's been very cooperative. To go over to, I think it's Oklahoma DHS. I'm rusty, but anyway, or take a lab test or whatever and get that done ASAP. I know he's calling, I think, from work today. He was kind enough to be here, so.
All right, that'll work. I'll go ahead and let the state try to set that up and do it ASAP, or you folks can do one on the side if you want to, and get it done, and I'll accept that. But again, I want to get them through the divorce part as quickly as possible. It sounds like that Mr. Williams is going to make this part of the case difficult, so we'll see. All right.
May I address
I know, Mr. Burkey, to go ahead and take that test, and we'll get it set up ASAP. All right.
Judge, if I may, should they do that on their own, would the court entertain simply receiving those results so we don't have to come back here and put in a holding pattern again?
All right, I'll go ahead and grant that. I'll grant them the opportunity to set it up through an appropriate lab and make sure they get the proper identification and the necessary paperwork to go along with it. And obviously, I will accept that. Okay.
Okay. Are we talking?
I am still going to go ahead and order a DNA test between Ms. Ryan and Mr. Williams on this one, because again, I got a strange feeling this person may not show up for those tests. So.
Well, and again, Your Honor, I think you're underlining my point, which is it's a presumption, and I'm not in the establishment business. I know the state is, but if we're talking DNA tests, are we talking going into something like any lab test now, or would a home test satisfy?
Let's make it official. Any lab test now. That's but they've been my go-to people for the last year. So yeah, and they're everywhere now. So
That was my question. If they're in Oklahoma or wherever, I'm gonna let the parties work it out through the state if they need to, but either way, I want to get this done ASAP.
good enough. Because I want them. Obviously, they've been separated for 7 years, and they need to put a period at the end of that sentence. And let's just go ahead and get it done. And again, I'll let y'all do it, and I'll go ahead and order the state to set up the DNA test between Miss Ryan and the alleged father, and they can go ahead and do an audit for Mr. Burkey also, just in case. But I'll go ahead and if y'all go ahead and set it up and get that one done, obviously the one with the state will become moot. Okay.
Judge, if I may, one last thing. It's my understanding that my former agency has a lovely document called an AOP DOP. Would it be possible to issue one to Mr. Burkey, and assuming that he properly executes that, would his signature of the denial with my client's verified signature on the top per the document, would that satisfy the court?
Yeah, I think I would need Mr. Williams on that document also.
Again,
okay, you're talking about the AOP, but the AOP with the has the presumed father, the alleged father, and the mom all signing off on that one. Is that what you're talking about?
That is what I'm talking about, but sir, Judge, what I'm wondering is, forgetting the DNA for just a moment, as the court is well aware, the state has an AOP DOP in their possession. And what I'm wondering is, would the court contemplate the state issues that AOP, my client as the bio mother signs it and says, of course, under penalty of perjury, this gentleman, Mr. Burkey, is not the father. Mr. Burkey executes the DOP on the bottom. Now, I don't have the AOP from Mr. Williams, but short of a DNA, would that satisfy the court?
Okay, now let's go ahead and do the DNA test, Mr. Gann. I want to nail this, and I'm thinking that one might be again legally problematic because there's not an AOP right now. I'm assuming they tried to do it, and yeah. So when we get those in there with the presumed father on there, everybody needs to sign off on it. And again, I don't think Mr. Williams is going to do it at this point. So.
Well, should he do that, that would be lovely. But otherwise, I guess we'll proceed.
Yeah, you get Mr. Williams to sign off on it along with both parties, we're good. So
understood. All
right. Anyway, let's see if we get this one wrapped up, and I'll go ahead and write this one up, and we'll get these folks get their marriage taken care of, and we'll worry about the thing with Mr. Williams and Miss Ryan once they get.
Yes, Miss Ryan. Yes, Miss Ryan. Hold on. Yes, Miss Ryan, you're muted.
Still muted, ma'am.
Okay. So with all of this, can I not file my divorce paperwork now, or do I have to wait until the DNA test is done?
No.
Or you need to talk to your counsel about that, man. About your divorce paperwork's already filed. I'm not sure what you're talking about, but again, I'll let you talk to Mr. Gann private on that one, ma'am. So thank you.
Okay.
All right, all right. I'll ask Mr. Burkey. You have any questions, sir?
No, sir.
All right, then I'm gonna go ahead and let them set everything up. Y'all can do the DNA test privately. Y'all can do it with the state, however y'all want to try to handle it, whichever's the fastest, and get y'all into finalizing your divorce. And we'll go ahead and set up everything with Miss Ryan and the alleged father, Mr. Williams, on our side also. Anyway, everybody's excused at this point. Does the state have anything else, Ms. Bungat?
No, Your Honor. Thank you.
All right.
I have a question for the state. Can Miss Ryan go into 704 and with the child and start that process today or next couple of days? I assume she could.
So my colleague's already scheduled her, and
okay.
There should well, yeah, it's actually set for. I can put Ill in a breakout room so the court can move on.
Okay. Thank you. Sorry, just want to make sure it was on record.
All right, thank you. All right, we're off the record at this point.